We're back on the record. We're outside the presence of the jurors. Mr. Prosper, you were finished, I believe, but now I think said you were finished, I believe, asking me to introduce grand jury testimony, but I also noticed that you were marking some things for the record. I would like for you to put stuff into the record if you wish to. That would be a good time to do that.
Judge, we would offer at this point in time Defendant's Exhibit A, which is the grand jury testimony. Specifically, it's the grand jury testimony of Dale Richardson, Christopher Hess, Aaron Evans, Ernest Embry, and Peter Liquor. Ernest Embry is the expert witness that the state sought out, as used before, put in front of the grand jury to offer his opinion as to speed and distance, and ask him about whether or not he, as a peace officer, I'm assuming it's part of it, they didn't ask him because he had a green tie on, whether or not he, had he been there, based on what he observed, would have been alarmed by the speed of the vehicle and the manner in which it was being driven under those circumstances. That would have created in his mind an alarming situation. He answered yes.
Right. And that's in the grand jury transcript.
That's in the grand jury transcript.
That's what you want to put in right now for record purposes.
That's what I want to put in to, again, go to the fact that the state, having this information, sought to make statements, both in opening statement and through other witnesses, that in effect detract from that information and give the impression of nobody could know what these people were doing because we don't even know if they were awake. And we would offer that for the purposes previously stated by us. We also would like...
Hold on, I'm going to do this one at a time.
Okay.
You're offering those for record purposes.
For record purposes.
Will you please let me finish? Defendant's Exhibit A, is that what you've numbered this?
Yes.
Ms. Wood, is that okay for you to call it
Yes,
Defense A?
I did. I'm waiting. Yes, let's.
Defense A is admitted for record purposes only. If you're asking me to introduce anything in Defendant's A in front of the jury, your request is denied. Next thing.
Next thing, we have defendants that she has marked, defendants B through M, which are the copies from the district clerk's office of, I lost count, 10 or 11 felony convictions of Rogelio Rosales, and we want those for purposes of the record and hopefully to be used subsequently against him when the appropriate time comes.
I'll admit them for record purposes. They're inadmissible at this point. If they become admissible later on, certainly I'll entertain an offer of proof at that time.
Thank you.
Next up is the request by Ms. Mattson, I believe, it might have been Mr. Harris, for the court to reconsider its ruling about Melissa Burt. The testimony is inadmissible. It's still inadmissible. I'm not letting Melissa Burt testify as to what I consider to be hearsay statements by Mr. Rosales. There's this issue of what has, I guess, this missing body cam footage by Officer Wilcox. It's my understanding that over the break, Mr. Lewis has talked with the keeper of the body cam at Dallas Police Department, and that person is going to download and give to you as quickly as humanly possible, right, this body cam from Officer Wilcox.
Yes, sir.
All right. And once you do that, I'm sorry.
Can I just state for the record, we discussed off the record, Judge?
No, not yet. I'll give everybody an opportunity to talk. I'm going to sort through all this stuff.
Okay.
I'm going to order you, Mr. Lewis, as soon as you get it, to give it to Ms. Mattson and the defense team. Regarding the use immunity, state's motion to grant use immunity, the record should reflect that that was information that was given to the defense in April. The actual document was not given until the trial. However, the substance of it was not unknown to the defense. at least as recently as April of 2019, and it is undisputed by the parties that the defense received a transcript from Mr. Gonzalez. And as that issue relates to this trial, there isn't anything else that I need to do with that. All right, now, I guess I'll start with Mr. Lewis. You mentioned you wanted to put some stuff on the record based on what we discussed at the side of the bench. The record should reflect that we did have a conversation, both sides were present, it was off the record. There was an issue about a body cam or testimony that was from Officer Eilish. Mr. Lewis?
What I was referring to, Judge, was my conversation, or my investigator's conversation with Detective Richardson, as well as the body cam guy. So the court had ordered us during the course of the break to make contact with DPD to see if we could find out about what occurred with these body-worn cameras. My investigator, Tommy Lenore, did make contact with Detective Richardson. He asked him specifically about Officer Wilcox's body cam. He stated that he had never seen the body cam, that he had never reviewed it, and he never pulled it to become part of his investigative file. However, subsequently, Investigator Lenore's next call was to Stephen Williams, who was Sergeant with DPD. He's the custodian of records for the body-worn camera program. And he stated that by looking at what's called evidence.com, was the cloud that I'm referring to, that he could see that Detective Richardson had pulled the video and had downloaded it. However, it did not make it into his investigative file because the DA's office did personally go and inspect the file, and it was not in there. Else we're going to turn it over to the defense. So it's not part of the file that we have.
And it's not part of the file you turn over to the defense?
Correct.
And so that I'm clear, Officer Wilcox's body cam footage, based on his testimony, that we don't have, and we can verify this, but at least the way that it appears to me is that it wouldn't show anything different than what was on Officer Hess's body cam, in the sense that they were together. Is that a fair statement or not?
No, sir. As the defendant is leaving the scene, his body cam turns off. So anything that happened after that would presumably be captured on Officer Wilcox's body cam. I would state if they were to try to admit that evidence, I would object to it being hearsay if it's any statements made by the defendant.
We're not quite there just yet. I'm going to reserve any thought or consideration about what to do once we get it until both sides have had an opportunity to review the body cam. And we'll certainly give you all an opportunity to do that. In the meantime, Mr. Lewis, is it your understanding that that is sort of in the works as we speak? Because
Yes.
if it's not, it absolutely needs to be by my order.
I can confirm, after just now speaking with Investigator Lenore, that he is leaving the building right now to go over to DPD to pick up not only that video, but every video that they have related to this case.
I sure hope that's the only one that Charlotte had. Okay, Mr. Harris, so we stood up for a little bit there.
Well, Judge, I guess the issue is, I mean, we could get the video. It sounds like they're making an effort to get it, but it sounds like that the lead detective had this video at some point. The records show that he downloaded this video, and it's upon the state to turn over everything. And, you know, we've got this officer that had spent some time with our client, Mr. Hess. This video could show his state, how he appeared, and it's something that we didn't have when we put this officer on and had to question this officer and not had the opportunity to see that before. And I just think that there just should be some sort of remedy regarding now getting something and not having an opportunity to review it before we have to put on our case and call this officer.
I'm not saying I disagree with you. I'm just saying I need to know what's on the video. I'd like for y'all to review it so that you can make a determination and more specific request at a later time.
Thank you, Your Honor.
Now, Ms. Madsen, you had brought up some things at the side of the bench regarding, I believe it was statements that were made by a witness to you or Mr. Harris or to your investigator regarding Eilish's statements. Do you want to put on anything on the record about that at this time?
do want to put on record, we've already had a hearing where Officer Hopkins stated on record that he had met with the DAs in interviews and told them multiple statements that were clearly exculpatory, and that he met with them and told them this, and that they had not turned it over. Additionally, Detective Richardson stated that he had told the DA's office that he thought the shooting was reasonable, and they made an intentional decision to not call him as a witness, and I've not received any notice of Brady information from interviews with him.
Let me just clarify what you're saying first of all. When you say they told him, or they've intentionally not called him as a witness, you're not saying that George or anybody on the team over there has told Richardson that. That's an inference that you're making. That's not a statement that Richardson told you, that
Yes.
one of the officers made, one of the investigators made to him?
Detective Richardson
Maybe, just clarify. Maybe I misunderstood.
Detective Richardson was routed down here and was supposed to be a witness yesterday. He was told he will testify after lunch. During the lunch break, he was not with them, and they came back and told them they would not be calling him as a witness, and he was released.
Okay. All right. Sorry, go ahead.
So we have Officer Hopkins making statements in interviews with them, and we are not given the notes on those interviews, which would be Brady. We have the lead detective on the case who is interviewed and prepped for trial and has an opinion that goes straight to the heart of the issue. They list him as an expert. Not only did they not turn over the notes from that interview, at trial they decide that he is not a qualified expert for the one opinion that goes against their prosecution. We have Officer Wilcox body-worn camera, which they have the exact same statement as I do that says that he had a body-worn camera. We have efforts in the file and the investigative notes of them attempting to track down missing videos. This is the one video that they did not attempt to track down. I would submit to the court that there's an investigative note where they tried to track down Officer Alish's body-worn camera. They did make attempts to track down other missing body-worn cameras. This is the one that they did not, and they have the statement that says it exists. And then we have found and interviewed Officer Alish. He was a Dallas police officer at the time. He left and was living in another state the first time this case was set. He has now moved back to Dallas, and he has, in his interviews with us, given us information that is Brady and exculpatory. He says that he has been interviewed by the state and spoke to them, and that they had told him that they would not be calling him as a witness. We do not have any interview notes from the interview with Officer Hopkins. We do not have any interview notes of the interviews and preps with Detective Richardson.
What interview notes are those?
Any interview notes that are made, I would anticipate that if these officers say things regarding the state of mind and the reasonableness, if notes aren't made, they should be.
Well, okay. I guess the only thing I'm clarifying, when you say interview notes, you're talking about what the state might have made if they did make. You're not talking about his notes or whose
No.
notes are you talking about?
No, I'm talking about the district attorneys and their investigators. When district attorneys meet with witnesses, they very often have investigators with them. One or both parties make notes. Those notes then become in the file. The best practices would be anytime there's any Brady, that is recorded of what Brady was given, what statements were made to the best of their ability in those interviews, the time and the date and who the witnesses are is recorded, and then it's turned over to the defense because we are entitled to it by law.
And does the representation that you made to me, or Mr. Harris did, I'm not sure which, was that Eilish's opinion is that this was a good shoot, basically?
Yes, it was reasonable and that it is a good shoot, that he has told the district attorney's office that he believes that it was a justified shooting and that he himself believed officers were behind that vehicle.
And Mr. Lewis, you made a representation to me that you had informed him that Eilish thought it was a good shoot, is that right?
That's correct, and if I can quote directly from the grand jury record, this is volume 1 on page 29. This is Officer Alish's testimony. Prosecutor asked him, so you believe that Officer Hess acted reasonable? Answer by Officer Alish, I do. Question, do you believe the number of times that he shot was reasonable? Yes. You believe that the second round of shots that he fired were reasonable? Yes. And he also states basically the same thing in his initial statement to criminal investigators back on January the 18th, 2007, that he assumed that there were officers behind the vehicle on the driver's side of the fence line and that the vehicle would be a threat to their safety. So there's more than ample information that's been turned over to the defense and discovery that Officer Alice believed this was an original shooting.
The first question I have is for this statement that was written, you said in January, I'm assuming right after this offense took place.
Yes, Your Honor.
And when was it turned over? I'm going to ask the same question about this grand jury's transcript that you read.
So the transcript would be the same time that we turned over the one on Gonzalez, I believe it was April of 2019. And then the statements.
While you're looking at that, Ms. Madsen, did you receive a copy of his grand jury testimony that Mr. Lewis is referring to?
I did.
Okay. Mr. Lewis, whenever you know when this statement was turned over, please let me know.
July 18, 2017.
Does that comport with your notes, ma'am?
The written statement I did receive at that time.
There was another statement that was attributed to the state. I believe that it's either to Mr. Harris, I'm not sure. I think this was to you. The state told Mr. Eilish that they're not going to call him on, or they haven't communicated with him in this trial. Could you clarify that for me, please?
Our investigator, Marisa Wallace, spoke to Officer Eilish, Your Honor.
Okay. What did y'all tell me at the side of the bench about that?
I'm sorry?
What did you tell me at the side of the bench? That the state hadn't talked to this officer? Is that the information that you had?
No, Your Honor, that the state had talked to him and they informed him that they would not be calling any of the officers. And then at another time, they told him he was disregarded and not going to be called in this case.
Is that true, Mr. Wood? Any part of that true? None of it true? All of it?
So the fact that we disregarded his testimony is not true. I believe it was also an accusation by the defense that I did not tell them when the trial date was. That is not true. We specifically told them that it was this week. We did tell them that we would not call him as a witness for the state, but I told him that he could be possibly called by the defense. As pertains to the way that the state presents its case, we can present the case any way we want to, and they have equal subpoena power to call these witnesses.
All right. Very good. Ms. Madsen, you had informed me that I think it's based on a constellation of some of the issues that have arisen that you were to ask for in this trial. Are you prepared to do that now, or would you like to wait for this body cam to come in before you do that? What would you like to do?
I think the totality of it all is important to the court. I believe that it will be important to see what we're dealing with. Additionally, I do want to admit the use immunity document that I was given as defense exhibit for record purposes. This is the only copy that I was given during testimony, so
I have one.
thank you.
You mark that, please. That will be admitted for record purposes.
Defense exhibit 40 for record purposes.
Any objections for record purposes, Mr. Lewis?
No objection.
Thank you. It's admitted.
And Your Honor, as to Mr. Lewis's comments that the state can try their case any way they want, he's absolutely right. But in doing so, and in making these decisions of what witnesses to call and holding out false impressions with the jury, it does make relevant who he interviewed, chose to call, and did not call. Those are strategic decisions. And this court has consistently told me that I cannot inform this jury who the state talked to, when they made decisions of who to call, and what knowledge they did at the time. I would submit to the court that the state has said in opening why, and that we could never know what was going on in this car. They have been told by multiple witnesses what is going on in this car, and they have intentionally tried to create a misperception with this jury, a false reality based upon their strategic decisions of what witnesses to call. And at that point, I would submit to the court that with not telling us that they've interviewed these witnesses, not telling us that this is
Hold on, who are
consistently
you
their
saying?
story.
Hold on just a second, because that is a very broad statement to make, and that is somewhat inconsistent with the information in front of you. Who are you saying that they interviewed that they never told you about?
They did not tell me the interviews and who they were disregarding. I would submit to the court, and all I'm asking is to be able to tell the jury the truth, that the DA's office is giving them a skewed perception of what actually took place that night. And in their witness selection of who to call and who not to call, there is a decision to create a narrative and not give all of the information and allow the jury to make the determination.
I will say to you that I will allow you to correct any false narrative that you feel like has been put forth by the state, but you must do so within the bounds of the rules of evidence that will govern this trial.
Yes, sir. We will need to know that if Mr. Rosales has his Fifth Amendment right, I believe he will need to have an attorney appointed to him.
That brings me to my next.
We would need to know if he's going to be available to testify.
Well, my bailiff just told me that Mr. Rosales is in a holdup. I didn't know he was coming. Who ordered him?
We did.
You want to appoint a lawyer for him to talk to you right now?
We would probably need to know if the immunity order you signed would apply to today, and there is a potential of perjury. We would probably need a ruling by you of what all it covers for that attorney. And our position is he perjured himself to the grand jury, and we intend to go into that. So we would probably need to be advised on that.
Okay. Do you intend on calling him now, or in your order of presentation, which you have every right to do? Or do you have another witness that you want to put on and I can take this up at a later time?
Not at this time. We don't have another witness.
So you want Mr. Rosales now?
Yes, sir.
Okay, very good. Court's going to take a very brief recess. There are any lawyers in the room?
Your Honor, actually, I will tell you that we do have 2 expert hearings we have to have. How you choose to do it is totally up to you. If you would like to do the expert hearings now, I just need to know by the end of today whether or not he's a witness that's available to us.
Mr. Rosales?
Yes. And I don't think you need to do it right now. If you choose to do the expert hearings, we're prepared to do that as well.
Sounds like we're not going to need the jury anymore today. Right?
Not for the state trial.
Okay. We're going to take a 2-minute recess, maybe 5 minutes. We're off the record. Recess. Mr. Johnson? Can I speak to
Cairo.
Yeah, I'm waiting. Try to get out the door quick.
He represents Mr. Rosales.
And the city.